All right, I will go ahead and get started. Welcome everyone to the third session of this year's Native Peoples of the Americas Colloquium, which is focusing on land back movements, Indigenous sovereignty, and self-determination. The Colloquium is an annual event at the University of Dayton, and it's part of a larger set of efforts to build connections and forge collaborations with Indigenous communities, as well as to foreground Native voices and perspectives on our campus. My name is Shannon Toll, and I am a professor of Indigenous Literatures in the English department here at UD. Before we start today's session, I would like to thank my fellow co-chairs, Dr. Teresa Segi and Dr. Tom Morgan, for their work and continued support as we've all been working together to plan this year's and previous colloquiums, and to thank the sponsors of Native People of the Americas Colloquium, which include the Office of Diversity and Inclusion, the Multi-Ethnic Education and Engagement Center, the College of Arts and Sciences, the Race and Ethnic Studies Program, and the Department of English here at UD. We would also like to thank Medicine Bow Forge, Wes Harmon for providing the artwork for this year's colloquium, and a very special thanks to Professor Kathy Cargill and her graphic design students, Natalie Ford and Evan Kurtz, for putting together the marketing materials and social media campaign to help us spread the word about this year's colloquium. Most importantly, I would like to thank all of our presenters for this year's colloquium, specifically for the ongoing work that they are doing to bring visibility, awareness, and change to the ongoing settler colonial violence that continues to impact Indigenous communities and nations, while testifying to the ongoing presence and vitality of Indigenous peoples and cultures. We are incredibly grateful that they have dedicated time to spend with us this year. So before introducing today's session and our speaker, I have two quick notes, a little bit of housekeeping for students in attendance. If you are here for PATH ABA credit, at the end, I will distribute a Google link in the chat that you will need to fill out to receive credit. Also, there's an upcoming opportunity through the Dialogue Zone on November 2nd to talk about what you learned at this year's NPAC. So please see a link in the chat for more information about that particular event. And now that the house is kept, let's turn to this afternoon's session. Our focus is on sovereignty in law and letters, and we are privileged to have Mary Kathryn Nagle with us this afternoon to discuss her twin careers as an accomplished litigator and a celebrated playwright. Nagle is a citizen of the Cherokee Nation of Oklahoma and a partner at Pipestem Law PC, where she specializes in federal Indian law and appellate litigation. Nagle has drafted and filed numerous briefs in the United States Supreme Court, articulating the connection between preserving tribal sovereignty and ensuring safety for Native women and children. Nagle also has extensive experience with numerous laws that protect the rights of American Indians, including the Native American Graves Protection and Repatriation Act and the Indian Child Welfare Act. Ms. Nagle studied theater at Georgetown University and went on to study law at Tulane Law School, where she graduated summa cum laude and was the recipient of the Judge John Minor Wisdom Award. Nagle has published law review articles and plays alike, and the plays include Manhattan, Misled, In My Father's Eyes, Sliver of a Full Moon, Diamonds Are a Boy's Best Friend, My Father's Bones, Sovereignty, and Reclaiming One Star. And now I will turn over to our esteemed speaker, Mary Kathryn Nagle.
Thank you so much for having me this afternoon, afternoon, I think it is. And I just am honored to be here and to be speaking with you all on these topics. That was a very lengthy bio. Thank you so much for reading the entire thing. Yes, I am a citizen of the Cherokee Nation. I am a playwright and an attorney, and those two careers really do go hand in hand and very much complement one another in ways that I still discover on a daily basis. And so, you know, when I'm asked to talk about sovereignty in the law and sovereignty in our theaters, there's a lot to discuss. And certainly it was brought up to me that folks are interested in hearing a little bit about McGirt, possibly also Brackeen. And I think that we can touch on all of those topics today. I know we have an hour and a half together. I had said I wasn't going to do a PowerPoint, but now that I think about it, I do actually have a PowerPoint presentation already made on sort of these topics. And so I might actually share my screen and just go through it because I do find it to be helpful. So let me see if I can, let's see, view slideshow. Okay, so this is a PowerPoint I've used before to talk about these subjects. And I very much see sovereignty as something that's, nations are sovereign, right? The United States is sovereign. The Cherokee Nation is sovereign. Muskogee Creek Nation is sovereign. The state of Oklahoma is sovereign. And what does it mean about sovereignty on stage? Well, I think the two are very, very connected. I start a lot of my talks off by talking about red face. And the reason I do that is because it is still widely practiced in the United States in the arts. This is a play called An Octoroon that is still very popular. It's a very well-written play because the author, Brendan Jacob Jenkins, actually takes a play called An Octoroon that features red face. Red face and blackface, and inverses the blackface. So instead of having white actors put on blackface and play slaves, which is what An Octoroon was originally written to do in the 1800s, he now has Black people put on whiteface. And it's actually quite interesting, and it's a fascinating commentary on how, in the ways in which theater has been used to dehumanize people and what it means to invert that, mechanism or tool, and to really expose the way in which a story has been told to dehumanize people. The only problem that I have with An Octoroon is that while they inverted the dehumanization of Black people with blackface, they just kept using red face. And so they put non-native people on stage in red face. This is a photo from the production. There's been numerous productions at professional theaters around the country. And they would have this native character get on stage and grunt and make noises. And that was supposed to be funny, I guess. It's not funny to Native people because these dehumanizing images have been around since the early 1800s, and they were originally created to dehumanize us. It is actually not a coincidence that in 1828, the year Andrew Jackson was elected to be president of the United States, the most popular performance in the United States at that time on Broadway was a red-face play called Metamora. And actually, Dr. Bethany Hughes at the University of Michigan has done amazing research on that. She's an amazing scholar that's looked into red face. She's a Choctaw Nation citizen, and she has documented the explosion of red face at that time. So you see that Andrew Jackson, who was a president who sought to exterminate my people, won a national campaign advocating for the extermination of my people, when the most popular performance of the day showed the extermination of my people literally on stage, and showed Native people as a caricature, as a dehumanized figure, the brunt of a joke on stage in Metamora. And so we know why these performances were created. We know for what purpose, and it's disturbing that they continue today. Oftentimes when someone like Brendan Jacob Jenkins uses red face in a play like this, and I talk to the playwright, right? If I get to talk to the playwright, I'll say, well, why did you choose red face? And they'll say, well, I think it's funny. I'm not trying to offend Native people. I love Native people. This is a joke. I'm making fun of it. And me, Mary Kathryn, think that it's impossible to make fun of something if you don't know where it came from. For instance, the N-word. Is it appropriate to, if you don't know where the N-word came from, can you actually make fun of it? I don't know that you can. And so I will ask people, well, it's cool, interesting choice. So you're making fun of red face. Where does red face come from? They have no idea. I have yet to find a non-native playwright using red face who has been able to tell me the origins of red face. And there's books written about it. In fact, Dr. Deloria, who wrote Playing Indian, wrote an excellent book if you want to research the origins of red face in America, why Americans are so obsessed with Playing Indian. It's called Playing Indian. It's a great book. But a lot of folks today in the American theater are repeating Playing Indian, and they don't even know where it came from. But so again, how ironic is it that Andrew Jackson ran on a presidential campaign of, hey, I'm going to exterminate the Indians, vote for me. And in today's culture, we're producing a play called Bloody Bloody Andrew Jackson that also uses red face and makes fun of Indians. And this is a scene from Bloody Bloody Andrew Jackson, another play on Broadway, no longer on Broadway today, but was very recently in the last 20 years on Broadway. And here they are, Bloody Bloody Andrew Jackson, they're dancing around the Andrew Jackson character, who is touted as a sexy man in tight jeans, a rock star. It's a musical. And again, the creators of that show said, well, it's a joke. And they couldn't explain where red face came from, or how Redface helped elect President Jackson and complete his genocidal agenda. They just thought it was funny to put all of that back on stage. It's just humor. And for Native people, genocide isn't funny. So it's not funny. And I think actually the fact that people still create and promote Redface about Native people is why Native people face the highest rates of violence in the United States today. Today, our Native people are more likely to be murdered, raped, assaulted, abused than any other population in the United States. And that's not a coincidence. That's because we have a culture that celebrates violence against Native people, and especially Native women. This play in particular, which has been, again, produced all over the country and is still widely accepted as a very appropriate play to do in America today. This song that you're seeing right here, I think this is from the scene 10 Little Indians, where they sing a song about killing Indians. As long as killing Indians and Indian people and indigenous people is a joke and something we promote, we're going to continue to see Native people murdered at rates higher than any other population in the United States. That's just a simple fact. But if anyone has any questions about what Andrew Jackson believed at the time, this is a quote from him in 1833 when he was addressing Congress. And he said about Native people, quote, "They have neither the intelligence, the industry, the moral habits, nor the desire of improvement, which are essential to any favorable change in their condition. Established in the midst of another and a superior race, and without appreciating the causes of their inferiority or seeking to control them, they must necessarily yield to the force of circumstances and ere long disappear." So pretty clear language. We're inferior. We're established in the midst of a superior race. We must move west, or we must disappear. And that was the very, very clear message from President Andrew Jackson at that time. I think it's important to note this research comes from Illuminative, and I'm very proud to be on their board. If you haven't heard of Illuminative, you can look it up. Illuminative supports Native artists, fixing curriculum in schools. Illuminative is an organization working on combating erasure of Native people in the United States, because we understand that our erasure is what allows systemic violence to continue and a lot of other systemic injustices. And so they did some research, found out that 87% of state history standards don't mention Native American history after 1900. Most kids in this country are taught that Natives were here before in history, but not here today. So they might learn about the Cherokee Trail of Tears, my nation's Trail of Tears in the 1830s, but apparently there aren't significant Cherokee people making history today, or significant Native people making history today. And I say today, I mean, after 1900 for the last 120 years, which is very, very problematic. And of course, this statistic comes from before the release of Rutherford Falls and Res Dogs. So that, of course, changes things. But I mean, it's not going to change it that dramatically. But when Illuminative did this research, only 0 to 0.04% of primetime TV and films have a Native character. So imagine that. I mean, genocide was a very successful tactic in this country. Like, we went from, millions and millions and millions and millions in population to, I can't remember how many, what the population size of indigenous people were, let's say in the 17 or 1800s, when we were probably at the lowest after all the genocide. Obviously, we know we have small numbers in the United States today, but to be 0.2, 0.04% of the folks that appear on TV, that is systemic erasure. So for me, the story of this is really, really personal. And I'm showing here my grandfather on the left. That's my great, great, great grandfather, John Ridge. And this is the cemetery where he and my other grandfather, Major Ridge, are buried. And that cemetery is in Cherokee Nation. It's in the very northeastern part of Cherokee Nation, and it's on our reservation. And this is where my grandfathers were buried in 1839 after they were assassinated. And they were murdered by our own people because they signed our removal treaty. And so in 1835, they signed the Treaty of New Echota. And then on June 22nd, 1839, on the other side of the Trail of Tears, and what is the Cherokee Nation Reservation today, in what is also known as Oklahoma, of course, then was the Cherokee Nation Reservation inside Indian Territory. our fellow citizens showed up at John Ridge's home, dragged him out of his bed, and stabbed him to death 40 times in front of his wife and 4 children. And so, I've grown up with this because my grandmother's grandmother was 4 years old when she watched her dad be stabbed to death. And, for our Cherokee people, my grandfathers were considered traitors because they signed this removal treaty and agreed to say, with President Andrew Jackson saying, okay, we'll move west of the Mississippi. We'll move to this new territory. We'll give up our home. And they did that because just a few years before, in 1832, they had won the most significant case in the Supreme Court ever to date for Indian tribes, and that was Worcester v. Georgia. And in Worcester v. Georgia, the whole issue for the court was, who has criminal jurisdiction over Cherokee lands? Is it Cherokee Nation or the state of Georgia? And the state of Georgia argued, well, of course, Cherokee Nation doesn't have criminal jurisdiction over American citizens on Cherokee lands. That would be unconstitutional. There's no way a tribe of Indians can exercise criminal jurisdiction over non-Indians. What the heck is that? And the Supreme Court looked at that and said, nope, absolutely not. The only sovereign with criminal jurisdiction on Cherokee lands is Cherokee Nation. And the United States has signed treaties with Cherokee Nation saying they're a nation. So they're a nation. And United States, state of Georgia, butt out, you don't have jurisdiction there, only Cherokee Nation does. And so really this decision, Worcester v. Georgia in 1832, ruined Andrew Jackson's plans for forced removal, because it really said that the United States didn't have jurisdiction over these lands. And so that really, really, really upset Andrew Jackson. And he refused to enforce the Supreme Court's decision. And so the state of Georgia instructed its militia to murder Cherokees, to rape Cherokee women. And that instruction was loud and clear. And so my John Ridge's father, Major Ridge, my great-great-great-great-great-grandfather, was the speaker of our tribal council in 1825 when we passed a law outlawing the rape of Cherokee women on Cherokee lands. And this is a copy of that law right here, passed in our legislative body, our national council, on November 10th, 1825, saying, anyone who rapes a woman on Cherokee lands, you will be prosecuted by Cherokee Nation. Any person. It didn't matter if you were a citizen of France, of England, of Germany, of the state of Georgia, of the state of Vermont, of Choctaw Nation, of Cherokee Nation. If you raped a woman on Cherokee lands, you're going to be prosecuted by Cherokee Nation. And my grandfathers worked on that. And this was in response to Georgia's tactics. They were using rape as a tactic to remove us from our homelands. That was in 1825. We won the major case in 1832, Worcester v. Georgia. Fast forward to 1978. And in 1978, the United States Supreme Court, in a case called Oliphant versus Squamish Indian Tribe, told tribes you can no longer exercise criminal jurisdiction over non-Indians who come onto tribal lands and commit crimes. And if you look at the case of Oliphant that the Supreme Court decided, that was a case where a non-Indian, Oliphant, came onto the Squamish Indian Tribe's reservation, got very drunk, and physically assaulted a tribal law enforcement officer who was trying to protect the public, and then engaged in a high-speed chase, which could have killed people. Luckily, it did not. So this is someone who was committing crimes on tribal lands and endangering the public around him, Indian and non-Indian. And the Supreme Court suddenly, in 1978, said, no, tribes can't exercise this criminal jurisdiction. So we lost that jurisdiction. Mind you, when my grandfathers were working on these kinds of laws to protect our women and our people on our lands, they also crafted laws to create the Cherokee Nation Supreme Court. We opened our Supreme Court in 1825. The state of Georgia didn't have a Supreme Court until 1845. So this idea that tribes, they refer to us as not able to govern, as illegitimate, as uncivilized. And of course, we have, a court is a very Western way of adjudicating different disputes. And we had dispute resolution processes in place within our governments across Indigenous nations on this soil long before Christopher Columbus ever got lost at sea. And a lot of tribes have now Westernized and have, like Cherokee Nation in 1825 said, okay, let's do a court like what the United States Supreme Court's doing. Let's do that. It doesn't really mean that one way is right or wrong, but the point is that our governments have been governing since time immemorial. And all of a sudden in 1978, the Supreme Court says, oh, you don't get to do that anymore. Pretty outrageous decision. Following the Supreme Court's decision in Oliphant, the rates of violence against our Native women and children skyrocketed. And the Department of Justice today reports that the majority, that Native women are more likely to be raped, murdered, or killed, assaulted, abused victims of violent crimes than any other population in the United States, bar none. So we face the highest rates of violence. The Department of Justice has also reported that the majority of the violent crimes against Native people are committed by non-Natives. So what does that mean? That means as a result of the Supreme Court's decision in Oliphant, tribal governments do not have criminal jurisdiction to prosecute the majority of crimes committed against their citizens. What you see here is a rally of Native women who came, and some allies, of course, amongst our men and our True Spirit relatives, came to stand on the doorsteps of the Supreme Court and demand justice during the Dollar General oral argument. What is the Dollar General case? Well, if you know what I just told you about Oliphant in 1978, that was a criminal jurisdiction case. There are two kinds of jurisdiction in tribal courts, in state courts, and in federal courts. It's known as criminal jurisdiction and civil. So criminal is like you commit a crime, you get prosecuted, you go to jail. Civil is, oh, this person, stepped on my foot and and I broke my foot and I want to sue them for damages. That's civil. That's someone's not going to jail, but you're suing them for damages. A real famous example is the O.J. Simpson trial, since the prosecutors for the state of California lost, or the county, I suppose. And but in the civil case, the family sued O.J. Simpson, right? That was a civil case. So that's a good comparison of civil versus criminal and how the two function. So if you think about this case, the Dollar General case, Dollar General owned and operated a store on the Mississippi Band of Choctaw Indian Reservation there in Mississippi. A 13-year-old Choctaw boy was interning inside the store, and he was sexually assaulted by the non-Indian store manager multiple times. The tribe cannot criminally prosecute because tribes don't have criminal jurisdiction over crimes committed by non-Indians. So it is a crime for someone to sexually assault a child, but the tribe, Mississippi Choctaw, couldn't prosecute. The United States Attorney's Office could have prosecuted, and they chose not to because they actually declined to prosecute the majority of violent crimes committed against Native people. They care a lot more about people transporting minivans of marijuana on interstates across states than actually people sexually assaulting Native children. And to me, that's sad, but that's so far how the Department of Justice has prioritized its priorities. So the crime was not getting prosecuted. In terms of civil jurisdiction, the tribe, the parents decided to file a civil lawsuit in tribal court saying that Dollar General had negligently supervised their employee, which is a very common tort case that people will bring when there's been sort of sexual harassment or assault in the workplace. They'll blame the employer because employers are supposed to train employees and actually create an environment where that's not allowed to continue unabated. And so it's a very common lawsuit to file. Dollar General, in response, didn't say, oh, actually, he didn't commit the sexual assault. We have information on this or that. Didn't dispute that at all. They said, actually, the problem here is that the parents have sued us in tribal court, and we can't be forced to litigate in tribal court because we know tribes have no jurisdiction over non-Indians. And the problem with that argument was that, yes, in 1978, the Supreme Court in Oliphant eliminated tribal criminal jurisdiction over non-Indians, but the Supreme Court had never eliminated tribal civil jurisdiction over non-Indians. And Dollar General in 2015 asked the Supreme Court to do that. They actually asked the Supreme Court to declare that tribes do not have civil jurisdiction over non-Indians who come onto tribal lands and sexually assault Native children. And the fact that they got away with doing that, and there was no sort of cancel Dollar General culture happening at the time, or a message. I mean, we started a hashtag shame on Dollar General campaign, but most Americans are still very happy to shop at Dollar General, even though they, I guess, want to safe harbor people who sexually assault Native children. It's bananas to me. But this is a rally that we organized on the doorsteps of the Supreme Court, and it was a pretty powerful day. We had hundreds of Native people get on buses and fly here and drive here from all over the country, show up and prayed on the doorsteps of the Supreme Court during the oral argument. And it really looked like we were going to lose that case. I was actually I filed an amicus brief in that case on behalf of my client, the National Indigenous Women's Resource Center, which is a national nonprofit working to end violence against Native women. And listening to the oral argument in that case, it really sounded like we were going to lose. There were 5 justices who were clearly asking questions against us, and 4 who seemed really for us. One of those 4 was Justice Scalia. Well, that was December of 2015. Before the decision came out in February of 2016, Justice Scalia passed away unexpectedly. So then we only had 8 justices on the Supreme Court. And when they issued their decision that next June, it was a 4-4 tie. And because it was a 4-4 tie, that meant the Fifth Circuit's decision below was upheld, and the Fifth Circuit had affirmed tribal jurisdiction. So at the end of the day, our prayers won, Dollar General lost, and Mississippi Choctaw maintained civil jurisdiction over non-Indians who sexually assault Choctaw children on Choctaw lands. It was a huge victory, but that's how close it is. And that's how much we're fighting just for the right to protect our children from sexual assault. But I think it's very closely related to the fact that like Disney makes films like Pocahontas, which celebrate the sexual assault of a Native child who was kidnapped, raped, murdered as a child. And we're going to change that into a love story and celebrate it in a mythological fashion, as if she was in love with her captor and her kidnapper and her rapist. And so I think that, we have a long ways to go to change a culture that has really promoted violence against Native people. This is one of the women who showed up with a shawl there at the I call it was a protest, but it was a sort of a prayerful movement. Everyone was praying and singing on the doorsteps of the Supreme Court. And her shawl here says, "Reclaiming sovereignty over Native lands and Native bodies." So I've talked about how that the Supreme Court in 1978 eliminated tribal criminal jurisdiction over non-Indians who commit crimes on tribal lands. In 2013, advocates, realizing just how high the rates of violence were against Native people on tribal lands, reached out to Congress and asked Congress to do something about it, and specifically advocated that in reauthorizing the Violence Against Women Act, that Congress restore tribal criminal jurisdiction over non-Indians for domestic violence crimes, since anytime a non-Indian abused a Native woman in her home, the tribe would not have criminal jurisdiction to prosecute those cases. And I will tell you that it was a very hard fought victory. Many people worked on it, and we eventually won. And it took a lot of hard work, a lot of convincing to convince folks that tribes should have this jurisdiction. And there were many people who opposed it. But on March 7th, 2013, President Obama signed into law the Violence Against Women Act, complete with a tribal jurisdiction provision. And you'll see here for the signing ceremony, the vice chairwoman of the Tulalip tribes, Deborah Parker, was invited to stand on stage with President Obama and Vice President Biden, then Vice President Biden. And you'll see also right here, I hope my mouse is showing up. This is Diane Millich, kind of standing right in front of the flag behind President Biden, or sorry, Vice President Biden, now President Biden. Diane Millich is Southern Ute, and she shared her story. They were both there for the signing ceremony. So here's President Obama signing it. I got to be there as well. Really powerful moment. This is Congresswoman Gwen Moore, who I just can't say enough amazing things about. She has been a huge ally when it comes to safety for Native women. She's one of the main reasons why this law got passed, because there was a moment where we were facing some Republican opposition to the tribal jurisdiction provision, and folks were saying, well, just take the tribal jurisdiction provision out. Let's just put VAWA through without restoring tribal criminal jurisdiction. We need to get VAWA done. And Congresswoman Gwen Moore said, absolutely not without our Native women. They face the highest rates of sexual assault, domestic violence, and homicide. And it's time that we start to correct this, and we cannot pass VAWA without increasing their protections and their safety. So she's a huge, amazing ally, dear friend. And but this is Diane Millich, and this is Deborah Parker, and they got to introduce, Diane Millich got to introduce the president and vice president, but she's famous for telling her story in the Times. And so I have created, one of the plays that I've written is about this story, about the Violence Against Women Act. And so that play is called Sliver of a Full Moon. And if you Google it, you'll see online, the American Bar Association did a Zoom reading of it last November. You can watch that version online. Harvard University, Harvard Law School did a staged reading of it in person several years before COVID. And so it was in person, and you can watch that as well. If you Google like Sliver of a Full Moon, and it's sliver, not silver, it's Sliver of a Full Moon. You can Google that and you can find those online. And so what I did in writing that play is I interviewed these women, Diane Millich, Deborah Parker, other Native women who stood up and spoke out against the violence and advocated for the restoration of the right of their own nation, their own government, to protect them in their own home. And I put their stories in the play. And then women like Diane Millich, who are survivors, I invited them to read their own stories, to play their own part. And they wanted to, and they did. And it was super powerful. It's always been powerful. We've done the play many, many times. We've done it on reservations and tribal communities. We've done it in law schools, from Yale to Harvard to Stanford to NYU Law. We've done it at the Fort Berthold Reservation. We've done it at the Umatilla Reservation, Eastern Band Cherokee Reservation, the Yurok Tribe Reservation in California. We did it at the University of Arizona Law School. We've done it for the National Congress of American Indian Conference. Congressman Tom Cole worked with us on the 1-year anniversary of VAWA. So that was March 7th, 2014. We did it inside Congress at the Visitor Center there on the Capitol. So we've performed the play multiple times. It's been an incredible experience to work with survivors, to create a space, a theatrical setting where they can share their stories of survival and advocate at the same time for their right to be safe in their own home. So that's my play Sliver of Full Moon. And that sort of transitions into my play Sovereignty. And so my play Sovereignty is actually the only play I've ever had published. So I'm still very much a new playwright. I don't have a lot of, this is the only play that I have published, but it's also had 2 productions. The very first one was at the Arena Stage in Washington, D.C. And the second one, which is featured here, this is a photo from the second production, was at Marin Theater Company in the San Francisco Bay Area. And this is the actress Elizabeth Francis playing the lead role in that play. And she is giving a speech. She is actually arguing in the play in front of the United States Supreme Court in favor of the constitutionality of tribal criminal jurisdiction. And it features a hypothetical case where a non-Indian defendant is challenging the constitutionality of tribal criminal jurisdiction over non-Indians, and is saying, oh, clearly that must be unconstitutional. And so, it's hypothetical because it hasn't happened yet. And, I think that I wanted to sort of create how I think it will go when this argument happens. And in my version of the story, we win. So I wrote it the way that I hope the Supreme Court will or how it'll come out. And one thing that's really cool about this play is that I have that in here. Okay, well, this is actually, so a couple things that are cool about this play. When we did it at Arena Stage in Washington, D.C., this is the Arena Stage production. So this is Andrew Roa, who's playing my grandfather, Major Ridge. This is Kalani Quapo, who's playing Andrew's playing Major Ridge. Kalani Quapo is playing John Ridge. And this amazing actor is playing Andrew Jackson. So we're actually seeing Andrew Jackson in my play. And it's sort of interesting to think about, this photo, right, compared to the image you saw of bloody Andrew Jackson, where Andrew Jackson, we're showing him, he dressed very well. He was a good dresser, right? He was the president of the United States. But we're not showing the Indians who are meeting with him as ridiculous buffoons in red face, and we're not making them the brunt of a joke. We're actually showing them in the clothes they wore at the time and appearing as they would have appeared at the time. And the costume designer for this show actually looked at historical photographs and did historical research to see what my grandfathers would have worn when they went to meet with Andrew Jackson, which, P.S., they did meet with Andrew Jackson several times in the White House. And in fact, my great-great-great-grandfather, John Ridge, when he met with Andrew Jackson after we won our case in the Supreme Court in 1832, John Ridge went to meet with him and said, what are you going to do to enforce the Supreme Court's decision? Georgia is not complying. We've shown them the case. They understand that they lost, and they understand that they have no jurisdiction on our lands, and that they can't continue to rape our women and burn down our homes and assign our lands to Georgia citizens in a lottery. Like they can't do that, but they're not stopping. And so we need the federal government to enforce the Supreme Court's decision. What are you going to do? And Andrew Jackson's response was, well, John Marshall, the Chief Justice of the Supreme Court at the time, made his decision, let him enforce it. And so just this is the power of storytelling when the people who've been silenced for hundreds of years actually finally get to speak out. Justice Ginsburg came to see the play at Arena Stage, and that was really, really amazing because, again, I'm looking for those connections between sovereignty on the stage and sovereignty in our courts. And at this point in time, when she came to see the play, no justice in the history of the United States had ever hired a Native law clerk. So we've gotten a lot more diversity on the court than ever before in American history. We have women up there. We have some people of color. That's great. We need way more women and way more people of color, I think. I love that Justice Ginsburg, when she was asked, when will we have enough women on the court, what number would be enough? She always said 9. We had 9 men for most of American history. What's wrong with having 9 women at one point? I think it'd be great. But to me, it's really significant that we as Native people have always been denied access to the court, and it's not for lack of trying. Not that I'm the most amazing attorney in the world, but I applied for 3 years in a row. I know several people who've graduated from, top-notch schools like Yale and Harvard and Columbia and Stanford who are Native, who have applied to clerk in the Supreme Court and have been denied. And so thankfully, Justice Gorsuch hired the first tribal citizen, and Justice Sotomayor hired a Native Hawaiian law clerk, and that's great. And we applaud them both for doing that. But it was amazing to have Justice Ginsburg come to the play and see the play, because this is the letter that she wrote me after that. And I think it shows that, this has had an impact on her, right? And okay. And sorry, I got distracted. I have puppies in the house and they're very cute and very loud. Okay. And so, not too long after she wrote me this letter, she, well, let's talk about McGirt for a second. So the final decision that Justice Ginsburg voted on before she passed away, the final thing she signed her name to, is McGirt versus Oklahoma. So what is that case? McGirt versus Oklahoma is a case where just recently, this was decided on July 9th, 2020. The state of Oklahoma had asked the Supreme Court to declare that Creek Nation no longer had a reservation. Okay. And why? Well, the case, you have to understand, technically was a criminal law case. And that's because if you have a reservation, okay, if a reservation still exists, then the state cannot exercise criminal jurisdiction over crimes committed by tribal citizens on tribal lands. Only the federal government and only the tribe can exercise criminal jurisdiction over crimes committed by Indians on tribal lands. To the same extent, like if the crime is committed by a non-Indian, that the state has jurisdiction, right? And the tribe does not. And so, so in McGirt, this dealt with a case where an Indian had committed a crime within the borders of the Creek Nation reservation, okay? And the state prosecuted him for that crime. And his argument was, well, the state can't prosecute me because I'm an Indian who committed a crime within a reservation. It has to be the feds or the tribe. And Oklahoma's response was, well, Creek Nation doesn't have a reservation anymore. So it's not really an issue because their reservation doesn't exist. And under the current law of the Supreme Court, under a precedent called Solemn v. Bartlett, you only get to say that a reservation no longer, if a treaty creates a reservation, okay, a tribe signs a treaty, the president signs it, the Senate ratifies it. We've got a treaty between the United States and a tribe creating a reservation. The only way to disestablish that reservation or destroy that reservation is for Congress to do that. A state can't say, oh, the reservation doesn't exist anymore. Congress has to disestablish it. And Oklahoma was asking this outrageous thing, which is, well, we know Congress hasn't disestablished it, and we know the courts don't do this, but Supreme Court, just do it. Just wink, wink. Just declare the Creek Nation without a reservation. Say it's gone. Say it doesn't exist anymore. And the Supreme Court looked at that and said no. And Justice Gorsuch wrote this amazing decision and said, actually, the reservation is very much still here. And so, what are you talking about, Oklahoma? Congress has never disestablished it. And it is a question for Congress. And if Congress wants to disestablish it, they certainly can. But until or unless they do, the reservation remains in existence. And that meant that for McGirt, the only sovereigns with jurisdiction to prosecute him for his crimes is the federal government or the tribe. P.S. Oklahoma argued that all hell would break loose and that it would be a horrible tragedy and there'd just be criminals running free everywhere. That's not the case. They're still saying that, even though there's no facts to prove it. Jim C. McGirt himself has now been sentenced to life in prison and will spend the rest of his life in a federal prison. He was prosecuted by the United States Attorney's Office. So, but what does this case mean? For Native people, it was a huge victory because we've just always been told, you don't exist, you're not around, you don't matter anymore. And the state of Oklahoma has been particularly bad at that. And so for the Supreme Court to say, sit down, Oklahoma, Creek Nation signed a treaty with the United States in 1866, creating their reservation. It still exists. It's not the end of the world. Okay. You're going to have to coexist with them just like you always have. They actually predate you. You didn't come into existence until 1907. They predate the United States. So calm down. And that was kind of the message from the Supreme Court. And we're still celebrating that, right? And so actually I wrote a play about that. It's not really about McGirt, but it's about a Muskogee Creek woman celebrating the decision. In fact, it's about my husband's mother, my husband's wife, not that'd be me, my husband's mother, my partner's mother, who was an incredible Muskogee woman. Her name was Jean Hill Chowdhury. And it's a one-woman play, and it's actually going to be workshopped by the Roundhouse Theater this April in person. Folks will have to show a vaccination card and or if they don't have a vaccine, a COVID test. And that's very exciting. That play is called On the Far End. And so it's upcoming. So McGirt is a huge, huge victory for Native people everywhere, but especially for Muskogee Creek Nation, because I think that for what I see as an attorney, I look at this case and I see that finally the Supreme Court is applying the law, just like they did in the case that my grandfathers worked on in 1832 called Worcester v. Georgia, where they won that case against the state of Georgia. The Supreme Court is applying the law and not giving in to white expectations of tribal erasure, right? Like this idea, because that was one of the arguments Oklahoma had, is like, but a lot of white people live here, so clearly the tribe shouldn't exist here anymore. And this idea that, well, if a bunch of white people move there, the tribe shouldn't be there anymore. They just need to not exist, right? Just like 87% of schools shouldn't teach that Natives still exist after 1900, right? There is a direct relationship between art and education and culture and entertainment and how it impacts the law. It's all related. So it's exciting to me that we're starting to see more and more plays by Native playwrights on the stage and more Native TV shows and films, because this will change the law. This is a photo of my play Mannahatta, which was produced at the Oregon Shakespeare Festival. It had its world premiere there, and it then went on to the Yale Repertory Theater most recently in February of 2020. It's about a young Delaware Lenape woman, Jane Snake, from the Delaware Nation in Anadarko, Oklahoma, who comes back and climbs the ladder to reach the top of a Wall Street investment firm, Lehman Brothers. This is monumental because Wall Street is named Wall Street for the wall that the Dutch built to keep her people out of their homelands, to keep the Lenape out of their homelands. And so she's coming back to this institution, and I won't spoil it and say what happens to Lehman Brothers by the end of the play, but it's all about coming home and about upending the narrative about what happened in our nation's history, because it's repeating itself. So everyone in the 2008 housing crisis was like, how can this happen? How can Wall Street take our homes? And I said, do you understand that Wall Street was created to take homes? That's why it's named Wall Street. It was a wall built to kick the Lenape out of their own homes. And so here, this is the scene where the Dutch purchase the island for $24. This is the scene where they think they've purchased the island from the Lenape. And this is a scene after the Dutch start taxing the Lenape to trade in their own homeland. And when the Lenape refuse to pay the tax, they just start shooting and killing them. And these are two sisters, Liliwayu and Tushkipakwisi, who are running away from the violence in the moment, fleeing the gunshots in their own homes. Again, we want to talk about why Native people face the highest rates of violence today, right? All you have to do is look at our nation's history and understand why it continues. Well, it also continues because of the legal framework we have. This is a play I did called Return to Niobrara. It was a children's play. We produced it at the Rose Theater in Omaha. And it's all about the story of Chief Standing Bear. It's a true story. He was a leader of the Ponca tribe, and they were forcibly removed on their Trail of Tears down to what is now known as Oklahoma. And that happened 1877. Or it was 1878, something close to that, 1877, 1878. And his son died on the Trail of Tears. And as his son, but after the Trail of Tears, after they got to Indian Territory and their new home. And as his son was dying, his 16-year-old son, he said, "Father, please bury me with our relatives up north along the Niobrara River, where we've always buried our relatives, because if you bury me here in this foreign land, I'm not going to be with our relatives. And I'm going to spend the rest of eternity just lost. And I want to be with our family. I want to be with our people." And Chief Standing Bear said, "Don't worry, son, I promise you, I will bury you with our people." And he took his son, Bear Shield, and unlawfully violated federal law and left the reservation. Back then, if you were an Indian who left the reservation, they would shoot you and kill you right there. And he walked north 500 miles to bury his son. He walked through blizzards in January of 1878 or 1879, 1879. And he was arrested by the United States and imprisoned at Fort Omaha. And 2 attorneys brought a writ of habeas corpus on his behalf. And the United States attorney argued in response, well, the writ of habeas corpus is not available to him because that's actually only available to all persons unlawfully detained. And we know that's what the statute says, the writ of habeas corpus. And Indians aren't persons under the law. And so the whole trial in federal court was whether or not Indians could be persons under the law. And this is him giving a speech at the end of the trial, which he really gave in real life, where he actually just said, "This hand is not the same color as yours," to the judge. He stood up and said, "This hand is not the same color as yours, but if you pierce my hand, I will feel the same pain that you feel, and my blood will be red just like yours. I am a man, the same God made us both." It's a powerful, amazing Shakespearean speech. And he won over that federal judge in 1879. Judge Elmer S. Dundee in the United States District Court in the District of Nebraska became the first judge to declare Indians to be persons under the law. A huge, huge victory for us. This is another play I have called Crossing Minnesota, and it was produced at Portland Center Stage. Still hoping that someday it'll have a second production, but this focused on the fight at Standing Rock, and my law firm actually filed a brief in that case as well, representing our client, the National Indigenous Women's Resource Center, because again, we know that Native women face the highest rates of violence in the United States today. We also know that extractive industries increase those rates of violence, and especially in the Bakken region in Western North Dakota, where because of the explosive growth in extractive industries from like 2005 on, you had hundreds of thousands of people who are not residents of the state moving to North Dakota, living in man camps, mostly men, to work in these oil fields. And a lot of them brought with them drugs and crime and other sex trafficking activities. And so they have the rates of violence against all people in North Dakota, but especially Native women and children in Western North Dakota are off the charts. We've got tribal law officers reporting incidents of kids being sex trafficked. It is horrible. And so our brief that we filed in the federal courts argued that the Army Corps of Engineers violated its own laws, because before it granted an easement to the Dakota Access Pipeline, allowing them to cross the Missouri River, but the Clean Water Act requires them to consider public health, safety, and welfare before granting an easement. And so a lot of people think about that as strictly an environmental calculation. And we made the argument that actually that is a calculation that must take into consideration whether or not granting the easement will increase violence against Native women, because it's already a crisis. And actually the Dakota Access Pipeline did increase oil extraction in the Bakken by 60%. And this is at a time when it was already like one of the most producing oil fields in the world. And so very alarming, that whole case. And of course, now, if you haven't followed it, it's still ongoing. It went back, the federal district court ruled, and this was affirmed by the DC Circuit, that the Army Corps of Engineers should have performed an environmental impact statement, but they didn't. So now it's back to the agency to perform that. And so this is a play that focused on on the controversy at Standing Rock and the movement that was started by youth. And so these are two high school students who, this student in particular was one of the students that did the runs, which the youth did to start the movement, where they ran and handed petitions to the Army Corps asking them not to grant the easement before they did. So this is the end of the photo slide, and this is the final moment in sovereignty. This is from the arena stage production, and it's the characters back at the cemetery with a modern day descendant, a baby Ridge, named after my grandfather, John Ridge. And so, I was also asked to talk about the Brackeen case. And so I do a lot of work with the Indian Child Welfare Act as well. And I will say, for the Indian Child Welfare Act, one of the best things you could do to educate yourself on it is actually listen to my sister's podcast. Her name's Rebecca Nagle, so it's pretty easy. It's just my last name, but put in Rebecca. And it's called This Land. And she has done an incredible amount of research on the Brackeen case. So whatever I say is going to be interesting and great, but it will pale in comparison to what you could learn by listening to her podcast, which is incredibly well done. The Indian Child Welfare Act was passed in 1978 in response to a crisis. At that time, if you understand the history of what's happened to Native people, you've got forced removals, you've got Trail of Tears. Then after we were forcibly removed, we were slaughtered in massacres by the US military. Then at the turn of the 19th century, late 1800s into the 1900s, the US military was like, you know what we should do? We're fighting them in the battlefield, but actually what we should do is take all of their children and strip them of their culture, strip them of their language, take them hundreds of miles away from their home and their family and their parents, and put them in boarding schools and force them and beat them to death if they don't speak English. And that was the boarding school experience. And then add on, of course, on top of that, a lot of sexual assault that happened. And so, so then we had boarding schools. And then just when that was starting to stop and everyone was kind of saying, yeah, maybe that's really not the best policy, then states started coming in and just taking Native kids out of Native homes and putting them up for adoption in situations where, things like, well, they weren't speaking English in the home. And so that's really not, or they weren't Christian, and all these kinds of things that are not legitimate reasons. Obviously, if a child is being abused in a home, or if the parents are drug addicts, there are some very clear reasons why you would remove a child from a home, regardless of the identity of the parents. But these Native parents were losing their children for reasons that had nothing to do with the actual best interest of the child. And imagine if the United States was losing 40% of its children. It's very hard as a nation to continue when you're losing almost half of your population, just to someone stealing them. And so Congress enacted the Indian Child Welfare Act to counter that, and to basically say, look, state agencies, when you go into a Native family and you try to remove a child, you don't just get to go in and say, oh, we're taking the child. You have to use best efforts to rehabilitate the parents and keep that family together. And if you ultimately determine that that person cannot parent, and you're going to terminate that parent's rights, then that child needs to first be placed with, if we can, a family member of that child. So if there's an auntie or an uncle or a grandma that wants to adopt the child, keep the child with the family. That's actually a best practice, regardless if it's a Native child, if for any child, right? Keeping a child with their birth family is just better for that child's mental health overall. Not that adoption can be a beautiful thing, right? But if we don't have to break up a family, why break up a family? So that is what ICWA is designed to do. It, of course, does allow non-natives to adopt Native children. It just says the first thing we're going to do with Native children, though, is we're going to look to see if their immediate family wants to adopt them. If not, another family within their tribal nation, or another Native family, because we know that family will be committed to keeping them connected with their culture as a Native person and their tribe. One thing that has to be very clear about ICWA, it's not a race-based classification. In fact, being Indian is not a race-based classification. You can be white, Asian, Black. You can look a lot of different ways and you have a lot of different races. You can look super Native. You can look like me and pass for white. If you're enrolled in a federally recognized tribe, you are an Indian under federal law. So in my nation, Cherokee Nation, we had slavery historically. It's not a great thing. It's a horrible thing. It's a reality of Cherokee Nation. We have citizens of our nation who don't quote unquote have Cherokee blood, but they are Cherokee. They are Cherokee Nation citizens because they, after the Civil War and after the Emancipation Proclamation was signed, tribes were signing treaties with the United States after the Civil War. Cherokee Nation signed a treaty with the United States saying, okay, you're giving citizenship to your ex-slaves that you're freeing. We're going to give Cherokee Nation citizenship to our slaves that we're freeing, and they're citizens. They can run for office. They vote. They have just as many rights, I think, as I do. I would actually defer to someone like Marilyn Van, who's an expert. I actually don't know. I don't think that our Constitution limits any of their rights, nor should it. And so the Indian Child Welfare Act would apply to them, right? Because their children are citizens of our nation. Again, it's about sovereignty, and it's about not allowing state governments who have anti-sovereignty interests or who just have racist bias against Native people or people of color or people who don't speak English or who don't worship Christ, and who maybe worship a faith that is just as legitimate but happens to be indigenous, about not letting those factors destroy families and saying, look, if a Native child's going to be taken out of a Native home, we just want to see if they can be placed with a member of their own family or another Native family first. And then if not, and if there's a great reason to place them with a non-Native family, that will happen. But ICWA sets up guardrails. It doesn't dictate the outcome, but it says this is how the process is going to carry out. You're going to consider this, you're going to consider that, you have to document this, you have to do that. You can't just take a Navajo kid out of the home because they're being taught to speak Navajo and not English. Not acceptable. You can't take a Cherokee kid out of a home because the mom doesn't want to take the kid to church. Not acceptable. So that's really what it was all about. We'll see, we won most of the issues in the Fifth Circuit, lost a couple. Both sides, the tribes and the non-Indian parents, have appealed to the Supreme Court. The Supreme Court has not yet ruled on whether or not they will grant cert in that case and hear the case. We don't yet know, but I urge you to listen to the This Land podcast season 2 to learn everything you possibly can about that. So I'm going to stop sharing my screen, and I know we have about 30 minutes left, so I would be very happy to open it up to Q&A. And I don't know, like Shannon, if you want me to read the questions or if you want to pick the question that I answer, how you might want to do that.
I think it would be easier for you if I read you. We're kind of curating questions. And so those of you who have questions, please type them into the Q&A. So we'll go ahead. Tom and Teresa will curate the questions for us and I will ask them so you can just focus on answering them. That way you don't have to be a one-man band up here. So this first question, it's kind of, someone would like for you to talk a bit more about how and why the Supreme Court took away Native and Indigenous courts' rights of convicting non-Indigenous people who commit crimes on reservation soil, so Oliphant v. Squamish. We did put a link to this in the chat, but I think they would like to hear you talk about this double standard and how they justified their ruling to take away prosecuting non-natives on Indigenous soil.
Well, so it's a great question. I'm going to be very honest. I think racial prejudice enters into it. I think there is a bias and a racial prejudice that Native people, and probably more so brown people, but Native people cannot fairly adjudicate the rights of white people, of white Americans, because if you look at what Chief Justice Rehnquist wrote in 1978, when he wrote Oliphant, he basically questioned the ability of tribal courts to fairly adjudicate the rights of non-Indians. And one of the things he said is, well, but a non-Indian will never be able to vote in their elections because you can't, it's all descendancy based. So even in the example I gave of the Cherokee freedmen, only the descendants of people who were Cherokee freedmen at the time of the 1866 treaty get to be Cherokee Nation citizens. You have to be a descendant of it. So, you can't just move to Cherokee Nation and become a citizen today, like you can move to Oklahoma and become a citizen of Oklahoma. And so Chief Justice Rehnquist was saying, well, there's just no way that, that we can guarantee that these people are going to be treated fairly in tribal court because non-Indians can't vote will never be able to vote in their elections. And I think part of that is a distrust of Native people, just an assumption that they're inferior. It goes back to what Andrew Jackson was saying, right? Racially inferior, established in the midst of superior race, uncivilized. Like those viewpoints have not changed. We have not yet successfully altered them in the United States. There's very much a prevailing belief that our courts are illegitimate. And it's shocking to me because I can't tell you how many times I've been in state courts where people have accepted bribes, people have, state court judges have clearly, issued racist decisions. We've got, states like Texas who have put to death people of color who DNA evidence later exonerates. And the Supreme Court's not saying, whoa, maybe we should take away their jurisdiction because they're not fairly adjudicating the rights of colored people, right? No. But the Supreme Court will protect white Americans if they feel like tribes might not be fair to them. So there's definitely racial bias involved. But that argument is also ludicrous if you think about it this way. The Supreme Court's never going to tell the state of Kansas, hey, Kansas, you can no longer criminally prosecute people who are not citizens of Kansas, but come into Kansas and rape and murder. You can't prosecute them anymore unless they're citizens of Kansas because they can't vote in your elections unless they're citizens of Kansas. That's crazy. If I'm not a citizen of Kansas, if I go to Kansas right now and murder someone, I don't get to say, hey, whoa, I don't get to vote in Kansas elections. Kansas shouldn't be able to prosecute me for the murder I committed in Kansas soil. That's ridiculous. So why does that rationale apply to tribes and not to states? Well, you only get there if you really fundamentally believe that there's something inferior about tribes. And the belief that tribes are inferior as governments, as sovereigns, comes from the Andrew Jackson era and the performance of red face. So it's just straight up racial prejudice. But the other thing I will say is the Supreme Court always cites precedent. So look at the precedent they're citing. They cite in Oliphant Johnson v. McIntosh, which is an 1823 decision, okay? And in that decision, the Supreme Court decided that tribes cannot claim legal title to their lands because they are, quote, racially or inferior savages and heathens. Language of the court, not my language. That's the Supreme Court's language. That case has never been overturned. It has never, ever been declared by the Supreme Court to be bad law. So according to the Supreme Court today, we're still racially inferior savages and heathens who can't claim legal title to our own land. And Chief Justice Rehnquist cited that decision, and he didn't cite the racially inferior savages and heathens language, but he did say, well, if tribes can't fully claim legal title to their own lands, how can they exercise jurisdiction over it? Therefore, because we decided Johnson v. McIntosh in this way in 1823, we get to decide Oliphant this way in 1978. So it is a very problematic decision for the Supreme Court. I will say that at the very end of the case, Chief Justice Rehnquist acknowledges that there are very high rates of violence against Native people in the United States today. And he says, but this isn't a question for the court to resolve. This is a question for Congress to resolve. And so if anyone's going to restore this tribal criminal jurisdiction, that's up to Congress. And that's how we got VAWA 2013.
I think as you're talking about sort of the very kind of inconsistent or the mixed legacy of the Supreme Court when it comes to Indigenous issues, when it comes to Indigenous cases coming forward. We did have an attendee who was curious about your thoughts on Justice Ginsburg's legacy, thinking about the Cheryl v. Oneida case, and but how kind of later on it seemed like she seemed to understand federal Indian law from a different perspective, and if you wouldn't mind commenting on that.
Yeah, so I will say, I have a lot of respect for Justice Ginsburg, but for a lot of us in the Native community, celebrating her as a hero has been a very hard thing for us to do because her decision in City of Cheryl is very problematic and is, I think, is full-blown colonial settler narrative. Like it's about as bad as it gets. And that's really problematic, right? I will say that, and a lot of people, Oklahoma argued and other people have argued that, she signed on to the right side of McGirt. She joined the Justice Gorsuch decision. That was the last decision she signed before she died. A lot of people have said, well, that decision, you can't square that with her decision in City of Cheryl. They're probably right. And I think she had a change of heart. Where did her change of heart come from? I don't know. And I would not, I think seeing my play had something to do with it. I think she also interacted with a lot of Native artists at Indian Art Market in Santa Fe. I think that, I just think that she had more interactions with Native people as her time went on. And I think that probably affected her to a strong degree. But yeah, City of Cheryl is a horrible, horrible, horrible decision. It's just a horrible decision.
No, I think I think it's important to look at that. We tend to create hagiographies for people, but like that we need to look at the body of work that they have. And that was definitely, when it comes to this, a bleak spot. We have someone who's curious, if the US recognizes tribal nations as sovereign, how do they have jurisdiction to make decisions about tribal governments and courts?
Great question. And we're sort of at this point where we're not really fighting that, and sometimes people will say that, like, well, wait a second, why do we have to listen to the Supreme Court at all? And true, right? Like, we predate the United States. How does the Supreme Court even get away with taking away our jurisdiction? Where in the United States Constitution does it say that the Supreme Court has the ability or capability or authority to remove jurisdiction from other sovereigns? It doesn't, right? So that's true. But I think also, we're just, we have sort of accepted the reality of, hey, the United States is here to stay. So are the state governments, and we want to coexist, and we want to coexist in a peaceful, productive manner, not in an antagonistic or harmful manner. And so a part of that is accepting the authority of the United States Supreme Court, which we just have done. And I think that's to the credit of our tribal leaders to say, we're not here, we're not slashing and burning. We understand the United States is here. We want to work with everyone in a respectful manner. We just need the Supreme Court to respect and uphold, our sovereignty too.
Yeah, absolutely. And on that note, someone would like to know if you could speak a bit more about the Cherokee Nation courts, their Supreme Courts, or maybe other nation courts, and how they are structured and how their sovereignty is recognized on whether it's state level or national level, how that works.
So the way in which our sovereignty is recognized on the federal level, it's in the United States Constitution. And it's in the United States Constitution. One, there's a reference to Indian tribes as one of the sovereigns that's contemplated, in addition to state governments and the federal government. So it's like the third sovereign that's mentioned in the US Constitution is the reference to Indian tribes. Second, the treaty clause says that any treaty signed by the president and ratified by the Senate becomes the supreme law of the land. And so we have all these treaties, and that's what Chief Justice Marshall said in Worcester v. Georgia. He said, look, treaties are the supreme law of the land, and the United States signed all these treaties with these tribes, specifically here Cherokee Nation, saying this is a nation and this is a sovereign nation, and this nation has its jurisdiction and has its authority and has this and that. And so those declarations of our sovereignty are, like, according to the US Constitution, the supreme law of the land for the United States. So that, and we say that tribes have a sovereign to sovereign relationship with the federal government. And that's because the United States got its sovereignty from tribes. When the United States came into existence, no one knew what the United States was. I mean, it was kind of like, who are these guys? They there's like these rebellious teenagers, fighting against their parents. Like England and France and Spain were like, oh, like, what is that a real thing? And what George Washington immediately did was start signing treaties with tribal nations, because he was saying to Spain and to France and to England to say, hey, we're sovereign too. You're signing treaties with these tribes. So are we, because we're sovereign. We're legitimate, just like you are Spain, just like you are England. We're signing treaties with Cherokee Nation and Creek Nation and Choctaw Nation and Shawnee and, you name it. So, so again, like, that's the recognition of our sovereignty, right? In terms of the states, states sometimes want to recognize our sovereignty, sometimes they don't. It doesn't really matter. There's nothing a state can do that would create or destroy tribal sovereignty. States post-date tribal sovereignty, we predate them. And, we hope to work with states. There are some states that are pretty good at working with tribes. Oklahoma is not one of them. So, and that's sad, that's unfortunate. Oklahoma's history, when Oklahoma was created, Oklahoma spent a lot of time and energy trying to destroy tribes.
Mhm.
And that's the sad truth. And they're still playing the same game they were playing in 1907.
Mhm. I think it's so interesting that the United States had to rely on the recognized sovereignty of indigenous nations in order to establish their sovereignty abroad. That's very interesting. Someone asked on here, how do you handle the emotions that come from facing these cases, especially cases that have to deal with a great deal of injustice? Are there many twists and turns and loopholes you have to go through to even present a case in this way?
It is, it's very difficult. And I will say it's very difficult. I do a lot of murdered and missing Indigenous women and girls cases. And so I represent the families of Allison Highwolf, Lindsay Whiteman, Rainy Hill, Sarah Stops, Pretty Places, Braven Bull. You work on all these cases, and there's more and more and more and more, and you're working with the families, and law enforcement won't even talk to them. Here it is, and oftentimes the person committing the murder is someone that's either an ex-boyfriend or is known. It's not a huge mystery who committed the murder. It's just that law enforcement doesn't care. They're like, oh, that's Native woman, poor Native woman on tribal lands. We don't care. We're not investigating. We're not prosecuting. If it's on tribal lands, the FBI has jurisdiction to investigate. They usually don't. They've been very disrespectful to our families in terms of, I represent Lindsay Whiteman, and the FBI, she was murdered on the Blackfeet Reservation a couple years ago, and FBI did nothing, even though everyone knows who killed her. It's no mystery whatsoever. The FBI just didn't investigate. And finally, just showed up at her brother's place of work one day and just handed him her clothing and said, here's what she was wearing the day she died. And we're closing the investigation, case closed. That was it. That was their communication with the family. So we're talking about a lot of trauma. We're talking about families who have been historically traumatized because they're descended from people who survived Trail of Tears and boarding schools and forced removals before ICWA. We're talking about a lot of trauma, and now, murders that are not being prosecuted. It is very, very, very challenging. It's also very depressing because, I've been advocating on all these cases. I have yet to have one success. And that's not because we don't have evidence about who committed the murder. We have that evidence. It's just, we have a federal government and state governments who do not care. And the tribes don't have jurisdiction because the Supreme Court took it away. So it is very depressing to do this work because I'm advocating, and I've yet to, even in one of the cases I'm working on, achieve a victory. So it's hard.
I think that leads into a question of how can more of this information about Indigenous history and legal struggle be incorporated into education and curriculum in the United States?
So that's a really, really great question. I think we've got to work to do that. And I think that Illuminative has focused on that. And so I defer to them and their role they've played, and they've created an initiative. And there's a lot of Oregon, for instance. I know the Native folks out in Oregon were working with the state to create more of a Native curriculum that can be taught K through 12. And so I think this does have to be more of a grassroots advocacy, in terms of people in the state of Missouri saying, hey, we don't have federally recognized tribes in Missouri today. Why? Because of genocide. But we know who was here. Oto Missouria, Osage, let's talk to them and let's have them advise us on how to shape and create a curriculum around Native history, right? Oh, hey, I'm in Tennessee. Okay, we don't have federally recognized tribes here today, but guess who was here historically? The Cherokee Nation. An Eastern Band is right there, Eastern Band Cherokee. Let's work with them, to create this curriculum. And so people, wherever you are, you can advocate with your state legislature, state board of education, your school district, to incorporate these kinds of curriculum, into what kids study and what kids learn. And I think too, like, there's so much power for English teachers and theater teachers and arts teachers, like to, for English teachers to teach Joy Harjo's poetry or Louise Erdrich's books, or, for a history teacher to take Suzanne Harjo's Nation to Nation, which is all about the history of treaties, and assign that in a history class, right? For a college level or high school level theater class to assign Larissa Fasthorse plays, or Madeline Sayet plays, or Delana Studi plays, or Bill Yellow Robe plays. Those plays can be read and because a teacher assigns them, even if the state isn't mandating it, and that can expose people to Native stories and Native histories that otherwise they wouldn't have any exposure to.
Mm-hmm. Thank you. Another question that we have is, I think maybe thinking about when you mentioned Standing Rock earlier, and maybe Line 3 as well, and some other pipeline projects that are happening right now. This student would like to know if tribal nations have jurisdiction or any control over the ability for companies to build pipelines through their lands. I know you mentioned the Army Corps of Engineers, but I think maybe a bit more clarification might be helpful.
Yeah, I think that, so yes and no. There could be some scenarios in which tribes would have jurisdiction over a pipeline going over tribal land. It's kind of complicated. In many instances, we do not, especially if it's off reservation and it's within historical treaty territories. And so that can be a huge issue. That was the issue certainly at Standing Rock, right? So the pipeline company went around the reservation on purpose so that they wouldn't have to deal with any kind of tribal law or tribal regulation or get a permit from the tribe. But in doing that, went through the tribe's treaty lands. And, tribes have treaty rights, even though we've lost a lot of those, like ownership of those lands. We have rights to be able to hunt, to be able to do ceremony on those lands. And you could see how an oil pipeline might disrupt those rights. And so, unfortunately, a lot of the categories of jurisdiction that tribes historically had have been eliminated over the years in the various ways that I've been talking about during our time together today. And, that has really, that has left tribes who are fighting these pipelines sort of at the will and the mercy of federal agencies who usually have the authority and jurisdiction to regulate these issues. And, when it's an agency like the Army Corps that is historically really disrespected tribal sovereignty and tribal rights, it can be very problematic.
That makes sense. We have someone who is curious if, because the doctrine of discovery has been invoked a few times in your discussion, and thinking about its effect on cultural erasure of First Nations people worldwide. And they were wondering why it still exists, basically, if there's a path toward it being rescinded. But I think the question also remains, like, whose responsibility is that? And could it have maybe effect in any sort of meaningful capacity?
I'm sorry, so why is what still in existence?
The doctrine of discovery, why it's able to be invoked multiple times. And I guess it's not a
did my Wi-Fi just go out? Shoot.
thing, should I suppose.
I think I lost you there for a second.
Oh, sorry. I think my connection was unstable for a second. I think just oh shoot, I think it's happening again. We got through so far.
Can anyone hear me?
I can hear you. Yes. Can you hear me?
Okay. Can you hear me?
I can. Oh dear.
Okay. Am I back?
Yes, you are.
Okay. Yeah. Sorry about that. Wi-Fi issues. I think I'm fine now.
No. It said my connection was unstable, so that might've been my.
Oh, okay. So I'll just go ahead and answer the question. Yeah, so there's a lot of attention paid lately to doctrine of discovery. Look, it's a horrible doctrine. It's a dumb doctrine. It's a doctrine that comes from the Catholic Church. And the idea is because we're going to Christianize everyone, God wants us to take the lands from the heathens and Christianize them. And then if we discover their lands, it's our lands. And that's just freaking ridiculous. I don't know anyone who's walking around today saying, oh, hey, I'm pro pipeline, doctrine of discovery, or like people aren't really directly citing it today, and because I think they know it's kind of ridiculous. So I don't see it as much of a threat. I mean, let's be clear, doctrine of discovery comes from the Roman Catholic Church. It got picked up in the United States specifically. If you look at Johnson v. McIntosh, that is a doctrine of discovery case. That case evinces the doctrine of discovery. Oliphant cites Johnson v. McIntosh. So Oliphant doesn't say doctrine of discovery. It cites Johnson v. McIntosh. And so the Supreme Court, especially, and governmental authorities in the United States today aren't saying, oh, doctrine of discovery, but they're citing its progeny. And so I'm focused on getting rid of its progeny. I want to get rid of Oliphant first and foremost. To me, that is the most important case to overturn in the Supreme Court right now. If we overturn the doctrine of discovery, that's fine. I just don't see how, if we get the first of all, it's a declaration by the Catholic Church. So I don't know if people, I guess, are getting the Pope. Maybe, I think the Pope did already say something. I don't know.
I think he lightly apologized.
Great. So he apologized. But like, right, like it's not like the Supreme Court's like, oh, we better reconsider Oliphant. Like, I don't think the 9 justices that are there today understand all those connections. And so I'm just focused on getting rid of Oliphant. I think, if people want to speak out about how bad the doctrine of discovery is, it's important to know that. But I'm not sure what abolishing the doctrine of discovery gets us today, because I don't think current lawmakers are citing it. But I do think there's something about culturally educating everyone on where it came from and why it's harmful and sort of all of that.
So kind of like it provides a framework that then becomes obfuscated in the different iterations that kind of continue forward. So I think I will have this be our last question for the day, because hopefully you'd like to speak about it at length, and someone would like to know what your favorite play is that you have written. Maybe talking a little bit more about your creative work as well.
Oh, that's such a cool question. Gosh, this is a really tough question. I don't know. I don't know that I have a favorite play. It's really hard. They're all my favorites. But I've done the most work on Minnehaha and Sovereignty. So they're kind of my oldest babies. So they're like my firstborns. And I'm just really, really, really hoping that they see more productions. They've both had 2, but I'm hoping post-COVID they get picked up and they get produced. But I'm also excited about my latest born baby, my baby, and that's my play On the Far End, which is going to be produced by Roundhouse. And it'll be workshopped this spring. I mentioned it before. It deals with the Supreme Court's decision in McGirt. So I'm super excited about that. It's a totally new play. And very, very excited about that. So but yeah, I love all of my plays, and my plays, like I showed, Return to Niobrara, and Crossing Minnesota, really would love to see those plays get produced again as well. It's hard, we're in this post-COVID period where, well, it's not even post-COVID, we're still in the thick of COVID, and theaters are starting to open up, but the first things they're going to do are produce the plays that got canceled because of COVID. And then they'll move on, which, my plays all finished right before COVID, which I was lucky. So I'm just reminding myself to be patient, that it could be a while before any of my plays get produced again.
Are there any great like indigenous playhouses? Is that the right word? Or theaters?
Native Voices at the Autry in Los Angeles is the best, and this, to me, like the front runner. They do really, really, really great work there. And then there's also Rihanna Yazzie in Minneapolis runs New Native Theater, and they do a lot of really, really great work there too. So I encourage you for folks to check out both of those theaters.
Great. Oh, that sounds awesome. And we'll have to look for your plays to be getting produced, and do let us know if you get any news about that, and we could post that on our websites and everything. So
yeah, absolutely.
Well, I thank you so much for being here today. I want to let everyone know that we have put the Aviate poll in the chat, and so that is available to you, and I hope that you all will kind of join me in silently clapping for our great speaker today. Thank you for being here and for joining us today. And I hope that you all will return for our 7 p.m. Panel as well on reclamation, recognition, and rematriation.
Okay, thank you all so much. It was an honor to be here with you.
Thank you.
Thanks.